Mtabiseng, thank you so much for joining us. You obviously kept an eye on proceedings this morning and various reaction to it. Like I just said to the representative of AfriForum, years ago, MPA said there was insufficient evidence, but then there was a lot of pressure put on them. Many saying because it was the son of Jacob Zuma. But again today in that judgment, repeatedly we heard insufficient evidence. This was not proved. Your reaction to the decision?
Well, I think maybe a few months ago, I was asked more or less the same question when the trial was in the middle, asking, especially after the cross-examination of the defense attorney for Duduzane Zuma. And he was mentioning the aquaplaning and how the car would have reacted. And he brought research, actually, as to how the Porsche of that year, that the car that Duduzane was driving, could have had that default within it. And that in itself was a very big defense when it comes to the culpable homicide. You must remember the state only had to prove 1% negligence on behalf of the accused, which is Duduzane here. So if they failed to prove just 1% of negligence, because here it's not intention, it's culpable homicide. So they had to prove 1%, they failed to do that. And it means that what was the initial reaction of the NPA many years ago was actually the case that there was not sufficient evidence to prove culpable homicide against the accused.
Now that decision to change, to turn around their decision and decide to go ahead and prosecute Zuma back in 2018, in retrospect, was that decision correct in the law? Or do we have to look at the decision against the backdrop of an MPA at the time that was under a huge amount of pressure with major questions being asked about its integrity?
Well, I think it will be the latter, which is the NPA at the time that was under pressure. Because usually what happens is that, let me just break down how it happens. You bring a case to the police station, you say that so-and-so assaulted you, for lack of another example. And then the police officers will then take the docket to the NPA. Then they have to decide whether or not they're going to enroll the matter. And then they check into the statements and the evidence thus far, whether there's going to be sufficient evidence to convict the accused. And if they feel that it's not sufficient, they will not enroll it. And then that's what happens. But it doesn't mean it ends there. The complainant has the right to follow up and find out if they're going to enroll this matter at all, and so on and so forth. They can take it as far up as the NDPP and see if this matter can be enrolled because they feel that it should be enrolled, which is what we can say happened with regard to Duduzane Zuma's situation. And that's why the matter ended up being enrolled, because there was a feeling that he has a case to answer to, like AfriForum has been saying. And I guess when it reached the stage of the application for Section 174 during the trial, the presiding officer at that time felt that, yes, Duduzane has a case to answer to. So that's why he did not give the 174 application. Hence, the accused had to get into the court and the defense had to open its case. So that's basically what happened. So it was the pressure that was put on by the complainant, by AfriForum, and maybe the families of the deceased. So, yeah.
Now, in giving his judgment, handing down his judgment earlier today, the judge said that Duduzane Zuma was a consistent witness. Yes. How much weight would that have in a case like this?
A lot. So cross-examination is a brutal exercise. Right? I think we've seen in the Oscar Pistorius kind of cases. So cross-examination, the aim of it is for me as the defense to prove my case. So if I am cross-examining the state witnesses, my aim is to get them to, to contradict themselves. So if I can get the state witnesses to contradict themselves in material aspects, already that's half the case won for the defense. So it's the same thing as the prosecution. When now the defense case is open, the prosecution does the same thing. Cross-examination is just as brutal. But if your evidence is consistent, and it doesn't matter how much I ask the same question in 10 different ways, your answer remains constant, then there's nothing the state can fault you, because in closing arguments, that's what we look at. No, he contradicted himself, he said this, but under cross-examination he said that. So the state clearly did not have a lot of that to point on the defense case. Hence, the defense case was a lot stronger than the state in this.
Now, during these proceedings, the prosecutor, Yusuf Baba, said, and I quote, "The court has to determine the following. Did Mr. Zuma drive the car as a prudent driver? Did he take precautions? And did he reduce his speed? He failed dismally." That's what they said at the time.
Yes.
But in that statement, they very much put all of their eggs in one basket, in that all of those questions they asked started with Mr. Zuma? Did he make a mistake? Did he drive to the best of his ability as a reasonable driver? Was that the right approach to make in this manner? Or should there have been more of a focus on proving the technical issues around the car and the tires and the water and the rain and the puddle and all of those things?
No. What basically the elements of culpable homicide are just simple, that you were, as the accused, you were negligent on the road, and you did not keep a proper lookout, and you were the driver of the vehicle at the said time, and you caused the death of the deceased. That's basically the elements the state has to prove. So the focus is actually on you as the accused person. So he was very correct to focus on that he was not a proper person driving at the time.
But from a technical point of view, it then makes it very difficult.
That's when we as defense attorneys have fun.
The human frailty then comes in, how the brain works, how you react, and all of those things.
Exactly. So these things are things, obviously, that are, if I'm not sure if they were able to have a pre-conference discussion, pre-trial conference rather, the state and the defense, and they put the cards on the table, say, I'm going to be going in this direction, this is what I'm going to look at. What evidence do you have to counter this? After that, and they continued with the trial, it's not like they were blindsided if a pre-trial conference was held.
Because you'd have been able to map out what the potential reactions would have been, because it's based on the law.
And if it is not as the aspect of the accused himself being in the wrong and actually being negligent is the correct term, then we can find fault in the actual vehicle, the road, all these other logistics around it. That's why things like inspections in loco are done, to go to the scene and see what happened and stuff like that, to look at the place itself, to give the defense or the state a better chance at winning the case. So yeah, the defense really had a good angle on this one.
Okay, great. Thank you so much. Great insight there. Our legal expert, Duduzane Zuma, thank you so much, for allowing us to pick your brain this afternoon.